Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. Har Har Mahadev Jai Shiv Shambhu. In today's class, we will discuss about an important topic concerning dismissal of complaint in absence of complainant. I am going to emphasize the same concerning the check cases. In check cases, there might be a position that in absence of complainant or due to his non-appearance, the court might dismiss the complaint. If the scenario occurs, serious perjury result to the rights of complainant. So, what a complainant could do and how to proceed, I am discussing the entire thing in the easy way. I request all of you to maintain the proper notebook with pen or pencil so that you could maintain the proper information on the subject. Whenever the scenario occurs, means the court dismiss the complaint in absence of complainant, the scenario is rare and rare because we are having ample guidelines in which it is specified that the dismissal should not be in the routine way. The court must have to issue notice to the concerned complainant, and despite of having the whole legal process, the appearance of the concerned complainant could not be ensured. In that scenario, the court may adopt the option to dismiss the complaint merely on the ground that the complainant is not coming from the last two or three appearances or proceedings. It is not a ground to dismiss the complaint. So if the complaint is dismissed in that scenario, despite of getting panic, just do one thing: go to your local counsel and ask him that I need certified copy of entire file along with the proceedings. We have to challenge the proceeding, means the proceeding in consequence of which our case has been dismissed before the consent trial court. Regarding this, we have to file the petition or application to restore the complaint. In the consent application or petition, we have to specify the grounds supporting the fact that why we were absent. We have to show that the grounds are legitimate, means genuine, and there is no deliberateness on our part. And in addition to this, we have to specify that we are ready and willing to participate in the proceeding, and if the case is not decided on the merits, in that scenario, the perjury will be cost to us. In multiple cases, it is seen that the concerned trial court might restore, and even they might refuse to consider your application on the ground that they are not having any power to recall or review their decision. As we know that a criminal court could not recall or review its order. The remedy lies before the Court of Revision or before Honorable High Court. But whenever there is a dismissal of complaint and you file the petition or application to restore the complaint, and ultimately the petition or application has been dismissed, the revision petition should be avoided because as per the protocol of revision, the order could be revised if the order passed by the concerned trial court is totally perverse. It is totally incorrect, and it is shown that the concerned trial court judge has acted against the principle of law. So if the order has been rejected on the point that the concerned trial court is having no power to recall or review its judgment, it means the view is correct, it is as per law. So the scope of revision will be on the lesser side and we might get a damage. So despite of that, we have to move before Honorable High Court as per section 528 of BNSS. As we know that the said protocol concerned with the inherent power of Honorable High Court, it says that nothing contained in CrPC or in BNSS. Previously we were having CrPC, now we are having BNSS. Prevent the Honorable High Court to exercise its power to prevent the abuse of process and to pass any order which is justified and required as per law. So basically we are having the view that the case could be restored, but due to certain restriction or obstruction by law, it could not be restored. So in that scenario, if the grounds are settled, it appears to be sound, and there is no deliberateness on your part, then you could easily get success from the concerned High Court. So basically I have specified you in which manner you have to proceed in case you face the panic that your case has been dismissed due to your non-appearance. So nothing is impossible. It depends in which manner we proceed and what is our strategy. If you are going to proceed in a manner which is non-specific or it might be non-strategic, then you might face a legal trouble. But if you are systematic, your pleading, your drafting is systematic, first of all, we have to note down the points, in consequence of which we could say that our absence is justified. If the points are not justified, even there is no evidence regarding the corroboration, and even our own view is self-inconsistent, then we might be in the hot water. Do you want to lose your case? I know that the answer will be in negative. So if you really want to avoid the said scenario, just work out on the specifications which I specified to you so that you could be succeeded in your approach. See you in the next video. Till then, Jai Hind, Jai Bharat.